Access to division records is a difficult discovery issue in family law cases. Essentially, division records are confidential, and they're maintained confidential by statute, and the agency works very hard to safeguard that information. There is a standard, however, in order for the court to gain access to the records and subsequently to share them with the attorneys in a matrimonial case. First, a party seeking access to those records has to allege before the court that there is information in those records that may be relevant to the court's analysis of the case. May be, not must be. At that point, the court will then order that the file from the division be turned over to the court. Once the judge has had an opportunity to at least review the records to determine if there's anything relevant in those records, the court then has the option of seeking to release information to the parties, assuming that there can be a three-part test satisfied under a case called State versus Cusick. That case requires that those records must be material to an issue before the court. They must be relevant. They must be not available from any other source, and most importantly, they must be likely to impact the outcome of the case. If you plead these things before the court does have the authority to hand them over to attorneys or to the parties, but only under a protective order to ensure that the confidential nature of those records is maintained in the case.